All right, good morning. It's 1 minute till 10. So we'll get started here in just a second. Want to make sure that we don't start early in case something momentous happens between now and 10 o'clock. All right, it's 10 o'clock. So good morning, everyone. My name's Joe LeClaire. I'm the zoning hearing officer for San Mateo County Planning and Building Department, and I'm convening the April 17th, 2025 zoning hearing officer meeting here at 455 County Center in Redwood City, as well as on the Zoom. And so I want to ask you all to join me in saying Pledge of Allegiance. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Okay, so the first item on our agenda today is public comment on matters that are not on our agenda. Is there anyone in the room or on the Zoom who would like to provide public comment on a matter that is not on our agenda?
We don't have anyone though, present in the room and via Zoom.
Thank you very much. Okay, so we will move on then to our regular agenda. And the first item is, Ted, can you please read it into the record?
Item 1, regular agenda. Planner, Summer Burleson, owner, Seaside View LLC, applicant, Kenneth Ho, file number PLN 2019-00386. Location, West Point Avenue, Princeton. APN number 047-034-160.
Thanks very much. Unfortunately, we're kind of the walking wounded here today. Summer's not feeling well, so she'll be presenting remotely. Good morning, Summer. Are you ready to present the project?
Yes, good morning. Can you see this in full screen?
Yes, we can.
Okay.
We can see you.
Okay, and it's not in presenter mode, showing up weird.
It's in presentation mode. Yeah, it's all good.
Oh, it is. Okay. Okay. So, well, thank you. My name's Summer Burleson. I'm a project planner with San Mateo County Planning and Building. And yes, thank you for the accommodation to present remotely while I recover from being ill. This item is an item continued from the March 6th, 2025 zoning hearing officer meeting for the consideration of a coastal development permit and design review permit to allow the operation of a kayak club facility on an undeveloped substandard sized 3,893 square foot lot located on the east side of West Point Avenue in Princeton. Just to briefly refresh our memories, this is for a portable modular unit with the deck and ADA compliant entrance ramp, 2 on-site parking spaces, wood and wire fencing along the site perimeter, a wood kiosk, and a water main line extension of approximately 50 feet along West Point Avenue to serve the development. During the March 6th DHO hearing, objection to the project was raised by Wayward Lot Investment Company. The basis of the objection is that Wayward owns a parcel south of the project site shown here and alleges that their parcel is free of being under Tidelands Trust under a Rancho lands exception as the land was granted. It was derived from a Mexican land grant and confirmed by federal patent in 1851. In light of this, their objection to the proposed project is that Wayward believes the project will generate trespassers across their privately owned parcel en route to the water, to which they do not give consent. Since the March 6th hearing, staff has had time to evaluate the documentation provided by Wayward. And staff does not find any evidence that would preclude the necessary findings from being made to approve the CDP and design review permit. County regulations and findings for issuance of the CDP and design review permit do not require a private development to provide direct access to the beach or the waterway. Land use permits issued with the county do not provide an authorization to trespass onto private property. And staff believes that any concerns over the right of trespass are a separate dispute that would not preclude the county from approving the CDP and design review permit that are being sought based on the findings necessary for approval. Therefore, staff does not see any evidence that prevents making the findings required to approve the CDP and design review permit, and staff maintains its recommendation for approval of the project as originally recommended. While staff does not have any opinion to offer as to the claim that the Mexican land grant accepts state lands commission authority, an inquiry was made to the state lands commission, and their feedback was that their records show that the Rancho boundary meandered the Pacific Ocean and did not include any tideland or submerged lands, and so does not provide exception from the public trust. Staff continues to find that the project conforms with the applicable general plan policies, local coastal program policies, and zoning standards. The project is categorically exempt from the California Environmental Quality Act pursuant to section 15303, class 3, for the location of limited numbers of new structures in an urbanized area with public utilities. For the total building square footage will not exceed 2,500 square feet, and no hazardous substances are involved. The Midcoast Community Council commented that they are in favor of the project and had no further comments, and conditions of approval from the California Coastal Commission have been included in the recommended conditions of approval and attachment A to the staff report. And a condition of approval from the last, that was recommended at the last March 6th hearing for skirting to be installed around the base of the unit has been incorporated into attachment A of the staff report as condition number 22. And so staff maintains its recommendation that the zoning hearing officer approve the coastal development permit and design review permit, county file number PLN 2019-00386, by making the required findings and adopting the recommended conditions of approval and attachment A of the staff report. And that concludes staff's presentation, and I'm available for any questions. Thank you.
Thank you, Summer. I don't have any questions at this time, so what I will do now is open the public hearing, and we have Mr. Callan, please.
You have 5 minutes.
Thank you, Officer Leclerc. I'll make this very brief.
All right.
Hold on, let me just share this.
I do have the papers. Can I hand them to you?
Yes, please.
I need to read the paper. I'm so sorry.
I can give it.
Not an invalid, thanks.
Thank you very much.
Yeah. No, not entirely.
I was, Summer's been ill. I only reached her 2 days ago, or yesterday, 2:45. That's when I learned of the opposition to the arguments that were raised at the last hearing. So I didn't have a lot of time to prepare a reply, but I have a reply and a suggestion. and I'm gonna start off again, I hate to say this to you, but I'd like to get a second continuance of the hearing. And I have a suggestion that should resolve all of these things in short order. Essentially, I don't believe an analysis done by the State Lands Commission is adequate. The application of the Rancho Lands Exemption is a legal issue. It's not an engineering issue. It's not a planning issue. It's a legal issue. And it's done case by case following a factual investigation. And essentially what it said, Mr. Officer Leclerc, is that if you own property that's subject to a Mexican grant and it's confirmed by a federal patent, it's free of the title.
I'm familiar with that.
Oh, great. Oh, great. And in this case, Princeton was all a subdivision of the Rancho Corral de Tierra. And it was confirmed by a district court in 1855. And I gave you a copy of the patent. I gave you a copy of the confirmation. And it seems odd to me that we're talking about kayaks that don't have legal access to the ocean. But getting past that point, I don't know what the records that the State Lands Commission has, or what Summer is referencing. But whether they show the parcel is submerged or not is irrelevant to the analysis decided by the Summa Court. That was the United States Supreme Court case that made the Rancho Lands exception back somewhere in the 80s. And what I was hoping after the conclusion is that someone would talk to county council. Why? Well, our case here really tracks the Martins Beach case. It tracks the Martins Beach case. And I mean, if Judge Buchwald was here, not retired, I think he could make it a very quick matter. But so could any county council who had anything to do with Martins Beach, because we have all the magic words. The person who married Mrs. Valencia was a senator, and it was a 7,700 acre piece of property. So every I was dotted, every T was crossed. You have the Mexican grant, you have the survey of the 7,700 acre parcel, you have the proper confirmation of the district. You have it all there, and I have it all done and prepared. But it really needs to have someone take a look at it with a legal background. County council who did Martins or assisted in Martins probably recognizes all of these issues and should be able to resolve it, toot sweet. So I'm just hoping we can get a continuance to give it a presentation. I'll make it myself to the county council to get a resolution, because I can't, what's killing me, and the reason I'm standing here is not a 600,000 square foot parcel in Princeton. I can't let a ruling or holding stand that the property is titleless. It's not titleless, it's free of the titleless trust. And that's all I really got to say. I think that would be a very brief resolution to it, but it really should go before county council because it's all legal. It's not engineering. The engineering department said there's no submerged lands and there's no underwater lands, but the patent included Deer Creek, Deniston's Creek, and people are right now enjoying Great Whale Beach and all these other beach lands that were grants from the Valencia property. So I think there's an inconsistency there. I think the legal department of the county could sort it out right away. And that's what I'm hoping we do. Thank you very much, Officer.
Thank you. So I'm going to take a crack at this Summer, and you can supplement as well. So we did share the information you provided. Well, I should say staff shared the information you provided last time with county council. They have been involved in the Martins Beach case. As a matter of fact, Summer's boss was sued by Coleslaw over his actions with regard to the Martins Beach case. So folks here are pretty familiar with Martins Beach case, and in particular, county council. The approval is drafted doesn't make a finding about tidelands. Am I correct in that, Summer? As you presented it?
That's correct.
Yeah, so what Summer said is that should you pursue this as a trespass matter that's not, it doesn't have bearing on, you know, our decision to approve the landside improvements and landside activities. Now, I consulted directly with the Assistant Deputy Director of the State Lands Commission, Grace Cato, Kato. She had one of her staff look into it. And their, as Summer summarized, their conclusion was that the property was subject to Tidelands Trust in part because the Rancho grants did not include anything in the Pacific Ocean. They're land-based. Now you may, you know, creeks, of course, that are terrestrial were included, of course, but that was their advice to us. Again, we're not relying on what the State Lands Commission told us with regard to Tidelands Trust. It just is information, you know, to us with regard to whether or not, you know, we might be setting up a trespass. But again, the approval is based on the land side improvements. I mean, there is some Tidelands conditions because this property and adjacent properties have illegally placed riprap in the ocean to counter erosion. And so the State Lands Commission has both required that the applicant work with the State Lands Commission to deal with the illegally placed riprap, and has required that they acknowledge that as sea level rises and coastal erosion continues, that it could put these improvements at risk, in which case they need to be poised to remove them and do so in a manner that protects coastal resources. So how did I do, Summer?
Yes, that's all. I agree.
Well, I guess, is there anything you would like to add to?
Just that, just to reiterate, yes, that staff did pass all of the documentation provided by Wayward to our county attorney's office to review, and did consult with them during this time period since the last hearing. And so our, you know, recommendation today for approval of the CDP and design review permit based on the findings that are required to be made are, you know, based on the limited findings under our regulatory authority. You know, the information provided relative to the State Lands Commissions and the Tidelands information is not part of that consideration within our regulatory authority, and was just providing that information that we received from the State Lands Commission as additional information. But it is a separate, the county sees that as a separate issue from the CDP and design review permit that we're responsible for acting upon.
Thank you. Okay, well, given all of that, I am not going to grant a continuance of this item. I am going to approve staff's recommendation pursuant to the findings and subject to the conditions of approval in attachment A. I will note that this approval may be appealed to the Planning Commission. And the date for submitting the appeal is May 1st, 2025. The deadline for submitting the appeal is May 1st, 2025, 5 p.m. and must be accompanied by a $1,962 appeal fee. Any questions? Yes.
But just to clarify, then, there is no holding that the Tylen's Trust is impacting this property, one way or the other. Is that right? That the
That's
Tylen's.
correct. We are not making that finding in that you don't, the staff report includes all the findings that we are, that we are relying on to make this approval. And we, again, we look to State Lands Commission and our county council for information about the Tidelands Trust and as sort of background information, if you will. And from it, we learned that one perspective is that the Tidelands Trust applies. And so, and to the property that you've identified and as your clients. And so that's information that we, considered. We didn't make a finding pursuant to, but we considered it.
If Summer or yourself, sir, could set me up with an appointment to meet with this Grace Cato, I'd be very appreciative. And that's all I have to say.
Okay. Yeah, it was informal communication with a former colleague. I used to work at BCDC. I was there for 25 years. So I spent a bit of time dealing with public trust. Grace and I were colleagues of two state agencies. So I reached out to her for information.
I can provide the contact to the lands grant manager, who I believe was involved,
Yeah.
Joe, in the
I think that would be,
correspondence that you had received.
of course, this is, Grace supervises this person. I think that would probably be the best place to start, the person who wrote us the information.
Thank you, Mr. Leclerc. And thank you. And thank you, Summer.
All right, thank you. And we will move on to item 2 on our agenda. Ted, can you please read that into the record?
Item 2, regular agenda, planner, Olivia Booth, owner Carlos Gomez, applicant Carlos Gomez, file number PLN 2022-00074, location 2796 Westmoreland Avenue, Redwood City, APN number 054-273-09.
Thanks very much. And Olivia Vu will present the project for us. Take it away, Olivia.
You have to click it. We used to.
No clicker.
Okay, I'll just guide you.
Just let me know.
That's okay.
Let's go to presentation mode. Oh, is someone presenting this too? No. I think someone's going. So yeah, just hit the presentation. Do you need to screen share? Can you stop share?
Oh. Do you?
That was Summer running it from her?
Yes.
Yeah, so.
Yeah, can you?
Yeah, I think
That's your problem.
Sorry, am I
Stop.
messing something up?
We just need to stop.
Sharing.
Yeah, and Ted has to do that. She's the one driving.
Okay.
Yeah.
Up,
No,
up, up.
No. See,
I have to share. I'm sharing the,
Oh, never mind.
yeah, and slideshow.
There you go.
Just let me know when to press, sorry.
Good morning, my name is Olivia Boo, project planner for the subject non-conforming use permit. Is to legalize 342 square feet of an addition to an existing 909 square foot non-conforming one-story single-family residence. The parcel size is 2,479 square feet. There is no tree removal and no grading, and the location at 2796 Westmoreland Avenue. Next. So this is just give you a location. The Westmoreland is corner parcels with Westmoreland Avenue on the right side, to the right side of the property, and then the property fronts on Dumbarton Avenue. So here are some photos. Photo A is taken from Westmoreland Avenue, and then photo B is showing you the right side of the house, also a view from Westmoreland Avenue. And C is taken actually further down, shows the rear of the property where the existing addition is. And this is a photo from Dumbarton Avenue showing the front of the property. Next. This is a closer look at the rear addition that is requesting to be legalized. Next. And then I wanted to point out the setbacks. So on the 10-foot side yard setback, because it's a corner lot facing a public right of way, the side yard setback is required to be 10 feet. And the existing house is legal non-conforming and was built at 8.85 feet. And this is to demonstrate that the addition does line up with the existing house. And so it is asking for an exception to be less than 10 feet. For the rear yard, where the 20-foot setback is noted, that is required to be 20 feet. And it's proposed at about just under 5 feet. And then for the 5-foot setback noted, that is required to be the interior side yard. That is required to be 5 feet. And again, the addition is lined up to match what the existing house was built at. So it has less than about 2.5 feet. Next. And this is the floor plan showing you the existing and then the pros. So in the blue is the closet that was constructed and requested to be legalized. In the red is a portion of a rear bedroom and then a laundry area. And again, the red portion is the rear of the property and the blue portion is towards the front of the property. And it was a carport and a deck. Looking at the upper floor plan of the upper image, there was to the right side, there was a carport and a deck that were there. And those were noted by Public Works as encroaching into the right of way. So these were required to be removed and actually have since been removed. And so the lower floor plan shows what is now and how it conforms. Well, it conforms in terms of compliance with the removal of the front structures, and then so that part has already been done.
Before you leave that
Yes.
slide, I just had a quick question. I note that there's an odd shaped parcel with the carve out. And it looks like there was intention for maybe a roundabout, or not a roundabout, but I mean a turnaround for fire trucks or something. But I just wanted to confirm that the roof overhang is not on that lower proposed floor plan. That's not in the right.
Yeah, as far as to my understanding, it's not there. They've actually removed portions that are not, that are.
And everything in the right of ways.
Correct.
Okay.
Next. And this is just an enlarged version of a large image of that same floor plan. Next. In terms of project conformity, it does comply in terms of the general plan and North Fair Oaks Community Plan. It is under the R3 S3 zoning district. It does comply for the height. There is no floor area limit. Next. And as mentioned, for the discussion purposes, it is asking for exceptions to the lot coverage and setbacks. In terms of the use permit, For the proposed development to be in proportion to the size of the parcel on which it is being built. The addition of the primary bedroom closet and the rear bedroom are reasonable to provide usable living space on the substandard size lot. This total lot coverage will only exceed the maximum allowed by 2 square feet. Regarding opportunities to acquire additional contiguous land in order to make the parcel conforming. All the contiguous parcels surrounding the parcel, the subject parcel, they're all already developed with single-family residences, or they're also substandard. So there's not an opportunity to acquire excess land from adjacent parcels in order to meet the minimum 5,000 square foot parcel. For the proposed development to be nearly in conformance with zoning regulations as reasonably possible. The project will allow reasonable usable living space on the parcel, while slightly exceeding the lot coverage by 2 square feet. And then additionally, the waiver of on-site covered parking. Although it is a waiver, it does not change how the property has been operating. It has been operating with no parking on site for some time. In terms of for the establishment of maintenance and conditions or conducting of proposed use that will not, under the circumstances, be detrimental to coastal resources or to the public welfare or to injuries to property or improvements to the neighborhood. The parcel is not located in the coastal zone. The neighborhood consists of primarily older 1- and 2-story single-family residences. It will maintain the current design standards and is compatible with the surrounding single-family residential development. It has been reviewed and conditionally approved by Menlo Park Fire District and Fair Oaks Sewer District, and is required to and conditioned to require to comply with Public Works. It is not, the residence is not out of character with the overall surrounding residential development. For the use permit approval, does not constitute granting of special privileges. The same exceptions would be considered by planning for other substandard parcels in similar or same situations. It is not considered to constitute a granting of special privileges that is not available to other properties in similar situations. For the environmental review, it was considered exempt for where the addition will not result in an increase of more than 50% of the floor area of the structure before the addition, or 2,500 square feet, whichever is less. And staff did receive public comment opposing the project due to the shortage of on-site parking. And it is known that the neighborhood and community is very crowded with street parking. The project was reviewed and considered by the North Oaks Council at the March 27th hearing, at which time the same public member did also express opposition at this project. They did not, they recommended approval. They did express concerns such as the interior 2-foot side yard setback, which is noted. But I did reiterate that it has been reviewed by the fire district, and they would have to make the necessary changes to make sure for fire safety. And then they did express note about the front additions, the carport and the deck that are encroaching into the right of way. And the applicant has confirmed that portions have already been removed. And next. And staff is recommending that the zoning hearing officer recommend approval of the use permit to legalize the front closet addition and the rear room addition with the noted substandard setbacks on this substandard 2,479 square foot parcel based on the conditions of approval of the staff report. And that is the conclusion of my presentation. I'm available for any questions, and I believe the applicant is available online.
Oh, great. I just had one question. So the fire department, excuse me, they wanted some kind of like hardening of the structure in some fashion to reduce the fire properties. That's all I have. If the applicant wishes to well, I'll tell you what, I'm gonna just open the public hearing. That was the only question I had. So I don't think we have any speaker cards for this one. Ted, is that correct?
We have,
We put the wrong, it was tagged as number 2 for us
oh,
on the thing, on the, out there, but it's actually, we're speaking on behalf of 3.
Three.
oh, 3.
Okay, so yeah, I have four, excuse me, 4 speaker cards for number 3, 4.
You could change that 3.
And none for, none for this one. That
Okay.
I can, yeah. But if the applicant would like to speak,
And we
That-
have one public comment.
oh, we have one public counsel.
Janet.
Oh, yeah, I read that. Thank
Okay.
you.
Yeah, I already,
That was transmitted with staff report, yes. So,
Mr. Vargas, are you online?
Let me,
they read.
Can you guys hear me?
Yes,
Oh, hi, everyone. Yeah, so, all that structure that Olivia said with the, it's been knocked down, that extra roof that was there in one of the, slideshows. It's all flat land now. And we've been in that property for over 20 years. You know, had no idea the way it was constructed. So we are trying to comply with everything that we can with the, you know, the regulations and the, codes from everyone.
thank you, Mr. Vargas.
No problem. Thank you, guys.
So I'm gonna close the public hearing and I will approve this project subject or pursuant to the findings and subject to the conditions of approval and attachment in the staff report. And if anyone would like to appeal this approval to the planning commission, they may do so. Written application needs to be submitted to the planning and building department by 5 p.m. on May 1st, 2025, and be accompanied by a $1,962 appeal fee. Mute them. And that concludes that item on our agenda. So we'll move on to item 3. And Ted, can you please read that into the record?
Item 3, regular agenda, planner, Randall Cohen, owner, Venus Carmigan, applicant, System Pavers Inc., file number PLN 2024-00247, location 545 Alta Avenue, El Granada, APN 048-064-290. Thank you.
Who are you?
I am Dan Bowman, I'm with System Pavers.
Oh,
will-
we're gonna have to
Yes,
show
What?
the presentation.
We're not, is he doing staff's presentation?
No, I am.
unless you like, am I out of turn?
Yes,
I'm sorry, I thought she called my name. I'm a little hard of hearing.
that's all right. We'll get to the public comment part in a minute. Thank you.
Okay.
Yeah.
Say your name, I thought you were. Sorry.
So Randall will make, Randall Cohen will make staff's presentation.
Slideshow.
Good morning. My name is Randall Cohen. I'm the assigned project planner here at the San Mateo County Planning and Building Department. I am bringing forward today county file number PLN 2024, or PLN 2024-00247 for a proposal. The applicant is requesting a home improvement exception for a new 380 square foot deck located in the rear yard of the subject property within the rear yard setback. The rear wall of the house sits at the 20-foot rear yard setback line. The proposed deck will extend out from this wall a distance of 8 feet into the rear yard setback. Because of the sloping nature of the subject parcel, the deck will be elevated approximately 11.5 feet above grade for the majority of its area. The residence is located on a developed conforming size parcel located in an area designated for single family residential use, with residences located on the side and rear property lines, with the exception of the undeveloped farmland to the south. Minor grading and no significant tree removal. Consistent with the requirements of the home improvement exception regulations, staff mailed out the required optional hearing request notice to surrounding property owners on October 11th, 2024. A request for hearing was received before the end of the noticing period, resulting in the hearing. The owner of the property is Vinod Kamigan, applicant System Pavers. Again, the file number PLN 2024-00247. Location of the property is 545 Alto Avenue in Miramar. APN 048-064-290. The project description defined consideration of a home improvement exception pursuant to section 6531 of the San Mateo County zoning ordinance for a rear deck addition to an existing single family residence. The proposed deck will encroach 8 feet into the required 20-foot rear yard setback. This project is not appealable to the California Code Commission. Here, just a quick slide of the vicinity map. You can see the property to the south on the left side, and just closer zoomed in, situated on the coast side. The property is on Alto Avenue. For the applicant and the appellant is the property behind. Next slide. It's a little bit more of a 3D view of the area. So the property is located in an area designated for single family residential use, with residences located on all sides, except for the undeveloped parcel farmland to the south. And just everyone's pointing to. Obviously, Pacific Ocean, north and south. Next slide. On this site plan, you can see the rear setback line delineated with the red line there. That would show the 20-foot rear yard setback. As you can see, the proposed deck would extend 8 feet from the rear wall into the setback. The applicant is requesting a home improvement exception or an HIE for a new 380 square foot deck located in the rear yard of the subject property within the rear yard setback. The rear wall of the house sits at the 20-foot rear yard setback line. The proposed deck will extend out from this wall a distance of 8 feet into the rear yard setback, resulting in a reduced 12-foot rear yard setback. Next slide, please. With graphic is the proposed elevation. You can see the sloping nature of the rear yard. And because of the sloping nature of the subject parcel, the deck will be elevated approximately 11.5 feet above grade for the majority of its area. Next slide, please. Objection to the proposed home improvement exception was received. Objection October 9th, 2024. Noticing of the proposed home improvement exception to the neighborhood began on 10/11/24 and concluded on 10/22/24. The noticing period included 1 extra day for a holiday on 10/14/24. On October 13th, 10/13/24, an objection was received. and a request for a public hearing was submitted by the neighboring property owner to the rear of the subject property at 548 Hermosa Avenue. The appellant expressed concerns that the proposed deck would compromise privacy, allowing neighbors to easily view the primary bedroom from the proposed deck. The appellant also stated that the deck would significantly impact the quality of life and could potentially reduce the property's value. Next slide, please. In this slide, you can see the applicant at 545 Alto Avenue, the appellant at 548 Hermosa Avenue. Though the rear yards are not immediately touching, it's connected via the property lines of the neighboring properties. Next slide, please. In these slides, just for reorientation here. Here's the rear yard of the applicant's property where the deck is proposed to go. And then over here, here's the same house where the deck would go. And here's 548 for the appellant.
Excuse me, I read in the staff somewhere that this was a replacement.
It was initially submitted as a replacement deck.
Oh.
When reviewed, it was being corrected to a new deck.
Okay, thank you.
Next slide, please. These are the images from 548 Hermosa Avenue in the rear yard. The view would show the applicant's rear yard and specifically where the deck would be built. Continuation going this way. Further here. Next slide, please. The red line indicates the approximate elevation of where the floor would be on the deck, viewable from the appellant's bedroom. Section 6565.20C2A, site planning and structure placement privacy in regards to compliance with COSI design review standards. Chapter 28.1 of the zoning regulations outlines design review standards for the development of new single-family dwellings and additions, specifically addressing the placement of structures and additions in order to protect privacy on adjacent parcels. As suggested, privacy is one of the keys to property owners' enjoyment of their property and the quality of life. Decks and balconies can offer or can provide outdoor living space and add architectural interest to a home. However, they must be carefully designed to avoid substantially affecting a neighbor's privacy. It is particularly important to consider the impact of the placement of the new structure, such as a deck, and or the windows may have on privacy, when setbacks are the minimum allowed by the zoning regulations. To the extent feasible, site and design new buildings, additions, decks, balconies, and associated infrastructure to respect the privacy of neighboring houses by locating, orienting, and designing windows, entrances, decks, and balconies to minimize and mitigate direct views into neighboring houses and outdoor decks or patios. Next slide, please. In compliance with the design review standards, in this instance, the applicant is requesting an exception to allow for a setback that is significantly less than the minimum required. Staff believes that this codified design standard cannot be met with the proposed project because the reduced setback and elevated nature of the deck will make it possible to look down into the backyards of the parcels directly behind the subject residence and directly into the adjacent bedrooms of those residences. In review of conformance with the home improvement exception, the findings. In order to approve a home improvement exception, the following findings must be made. The existing structure has a design or there are conditions applicable to the property such that the proposed project would result in only minor exterior changes. The house sits at the rear setback line, resulting in almost the entirety of the deck encroaching into the rear yard setback. The house does not have a unique design, nor is there a unique situation involved in this request. The proposed deck would create a substantial amount of active living space that would be highly visible to the adjacent properties to the rear of the subject parcel. Next slide, please. To approve a home improvement exception, the following findings must be made. The home improvement exception sustains the integrity or enhances an existing design concept or the neighborhood character. The subject house, as designed, was placed right at the rear setback line. The subject house was designed to emphasize the open views to the south and not the adjacent residential uses to the north, the rear of the property, as demonstrated by the minimum number of windows along the rear face of the house, which helps to maintain privacy for the adjacent properties, but also emphasizes the lack of views in this direction. The proposed deck would intrude into the privacy of the adjacent properties and disrupt the neighborhood character. Further conformance review. The granting of the application will not be detrimental or injurious to the property or improvements in the vicinity. It will not be detrimental to the public health, safety, general welfare, or convenience. As discussed in the staff report, the requested exception to the zoning regulations will impact the privacy of the adjacent parcels to the rear of the subject property. The proposed deck would allow an observer to look directly into both backyards of the rear properties and directly into the bedroom of 548 Hermos Avenue. Further compliance review. The home improvement exception is consistent with the objectives of the general plan and zoning regulation. As discussed previously, staff believes that the proposed deck conflicts with visual quality policies of the general plan and is inconsistent with the COSI design review standards as codified in the chapter 28.1 of the zoning regulation. Hearing officer denied the home improvement exception, county file number PLN 2024-00247 by making the required findings listed in attachment A. I will give my time back to you.
Thank you, Randall. I don't have any questions at this time. But I do have 4 speakers cards. So what I'd like to do is open the public hearing, and the first person who submitted a card is Dan Bowman. Dan? It's under your.
Hold
morning.
on, let me-
Good morning.
I have
We
not
do,
been here before, so please feel free to correct me on issues of protocol or other matters. I was not aware also that I could have done a PowerPoint. So may I give you these printouts?
Sure, yeah, you may. Thank you.
Dino and his family initiated this whole process because of life safety concerns of the existing deck and stairs. And also because their lot is sloped from the driveway or east side toward the west significantly uphill, and they have virtually no usable backyard. That's what prompted this. If the first exhibit is only to show you the side view of what's proposed, that's that one. And if you look at the next one in conjunction with that, the important point is that the height of the deck addition is no higher than what already exists. On the third page, the part closest to the house that juts into the house is the existing deck. And this shows the deck addition and the stairs down, which are replacing stairs that are also there. Although the stairs are moving out a little bit. The objections that I saw included obstruction of view from the neighbor on Hermosa. And in fairness to that neighbor, the information that was sent out really didn't address where this deck would be located. So the purpose of that site view, the one you're looking at, is to show that there's no obstruction of the view to the south, because nothing's being constructed on that side of the house. The view to the west and southwest is virtually unchanged because it's uphill from the Hermosa property and doesn't really block it. There's no view there. Lastly, with regard to privacy issues, this photograph is from the existing deck, whose height will not change. And so there'll be virtually no new impact with regard to the view from the new deck to that home, because the height of the deck is going to remain as you see it in this picture.
Except that the deck would be closer and, well, closer in two ways. One, excuse me.
From that rail, you see the handrail?
Yes.
If you go to your left at about a 45-degree angle, that goes out 4 feet.
Yeah.
So the difference in the sight line would be a matter of inches or perhaps a foot closer.
And the person standing, would the deck be constructed in the direction of this person standing in the yard?
No, you see the stair rail down in that picture?
Yeah.
That's going to remain there. That's the same.
That's the edge of the deck?
That is the edge of the
Proposed
deck.
edge of the deck?
Yes.
But you said the stairs were going to move.
The stairs are, so the, from where that handrail is, the deck is going to move, I'll just say to the left at a 45-degree angle, out 4 feet. From the picture you're looking at, if you just draw a straight line, left to right, come out 4 feet. That way, right?
Mm-hmm. Okay. Anything else you'd like to add, Mr. Bowman?
There was also a mention of impact on home values.
Just FYI, we don't consider that.
Perhaps self-serving, but I really feel that the addition of quality composite deck with attractive railing is not going to impact anybody's home values to the negative.
Thank you very much. The next speaker is Vinod Armagam. I hope I said that properly.
I have very little to add. Good morning, sir.
Good morning.
This is my first such review, so please correct me if I'm making any procedural errors with this applicant.
No, you're fine. You have 5 minutes.
I don't really have a lot to add, but based off of those pictures, it is basically a life safety issue, such that if you look at that particular picture right there, that comes out of the kitchen and it goes downwards. So that stairs has pretty much rotted, and what we thought we would do is we would replace that stairs, that deck, and then pull it up a little bit so it wraps around to the other front of the house, to the other side of the house. The reason why we decided to do that was because of the way that slope is. It's more than 1 floor difference. You see that slope?
Yeah.
So my father has fallen down that slope. I have fallen down the slope. In fact, I have a broken toe because of rolling down that slope. So the whole idea was to just basically connect this two, and so that whenever we take out the trash every week, try to go down those stairs, we don't slip and fall because the thing is pretty much watered right. So that's the goal of how this is. In terms of the view, I have a video, I don't know if I can share with you. So I took it from how I would come out from the kitchen and start looking around. The view is not going to be any different in my opinion from what already exists right there. Like when I come out and open the door and try to go down, the view is the same towards the back, right? It's just that it could wrap around a little bit. So in terms of a view into the bedroom, you can see also in one of those pictures that was attached. This was done with picture, right? So this picture was done with one zoom, so that it looks like how we would look like and how we would perceive the image. And this is the image that we perceive from the existing, literally standing at the deck. That's how it looks like. The intention was never to pry into someone's house. It was just to create a safety issue while we're building it up, just to wrap it around so that people don't roll down from the other side of the house, and to connect basically these two floors via the deck. So that's all I have to say. In terms of privacy, if the need arises that I need to put something like a guard, like, you know, like if this is the deck and you want me to raise something up there so that we don't get to see the neighbor, open to such suggestion. That's all I have to say. Thank you.
Next speaker is Lisa Ryan.
Maybe I can go first. Is that okay?
Sure, Sam.
Yeah.
Kiamarish, thank you.
Yeah.
Sorry.
Sure.
Please, yeah.
Yeah, my name is Sam Kimanish. I represent Lisa Ryan, and thank you for holding this hearing. Basically, the report that planning officer, Randall Cohen put together, we agree with. The proposed project violates, it's an exception to the housing, the zoning, and the exception, it's not a matter of right, it's a matter of it satisfies certain conditions. As you see in this report, it's very clear, very well laid out on every level. It violates the the sort of the intent of the exception and also the specific rules of the exception. The view that that my client is concerned about, and that was mentioned by the applicant is and the owner, was not the view of looking at the ocean. That it was looking at this bigger deck that would almost entirely intrude or encroach on the setback. This deck, the existing structure is a very skinny little tiny deck. It's not even a deck, it's really a walk down to the property. It's not a place where people will congregate, will hang out. It is just something, it's an exit, probably for fire reasons or safety reasons. And that can maintain, that can stay, that can be, repaired if necessary. What is being asked for is not the continuation of the existing use. What's being asked for is an encroachment of the entire new structure onto the setback, and the view would be from my client's backyard and my client's bedroom would be looking up at this much larger deck, and people standing on the deck. So the diagram that Mr. Cohen had was, you'll see the floor of the deck is, he had that line on that diagram. That's the floor. That's not the people stand on that, and so they're going to be well above that, looking down.
Mm-hmm.
So that's the view. That addresses the view. It's not a view of the ocean being obstructed. It's a view of now looking at this deck and possibly people congregating and having parties or whatever on that deck, looking into her, looking at that. The privacy is obviously looking in the other direction, looking from the deck down into her backyard and looking into specifically the bedrooms and her primary bedroom, which is the most private room in her house. And if that deck is built, she would, as she mentioned in her email that was attached to this report, what would happen is she would be forced to keep those blinds closed, those curtains closed, no natural light. The bedroom's on the lower level, no natural light would be coming in to that. You can't put skylights in. And generally it just impacts her privacy of the most private area of her home. So it would be devastating for her quality of life, and her enjoyment of the property, to grant an exception to the zoning. It's not even a conforming use, it's an exception. And that would benefit the owner at the detriment of my client. Anything else I wanted to add? I think that's primary. That's it. I think that there's plenty of support for denying this project in the report, and we agree with the findings in the report.
Thank you. Now, the last speaker I have is Lisa Ryan. Is there anybody else?
Hi.
Hi.
Nice to see you. Thank you for having me. So I've lived at 548 Hermosa for 10 years now. And as you can see at the back of the house, there are very few windows. The back of the applicant's house. There are very few windows, and they're very narrow windows, because the only views from that side of the house are into my backyard, my neighbor's backyard, but specifically into my master bedroom. The existing staircase where it is now, there's just a small landing. So nobody hangs out there. There's nobody hanging out, eating dinner, having parties, looking directly into my bedroom. So by having this deck, I would lose so much of my sense of privacy in my bedroom. I'd have to keep my blinds closed. And as far as the view, I would lose my ocean views because I would have to close my blinds. The thing that I really don't understand is the front of his house has a deck, and it has southward facing views into the adjacent farmland and in the distance, the ocean. If he wrapped around the front of his deck to the west side of the house, which has a larger yard and wouldn't encroach into the setback, he would potentially have ocean views. The only views he would have by putting on the north side of the house and encroaching into the setback is into my bedroom. And I take exception to that. I think all of us deserve our privacy, and the way that the house was designed was to preserve the privacy of the people who live to the north. And so yeah, I'm having an issue, and would hope that you would agree with Randall and his findings. And I ask that the exception be denied.
So is there anyone else who would like to speak on this matter this morning? Anybody online on the Zoom?
We don't have anybody else in the room, and we don't have anyone via Zoom.
Great, thank you. So I'm going to close the public hearing, and these will be submitted and stamped as public hearing exhibits. So I want to make clear, and I think Randall's staff report did a good job of laying out what are the criteria that the county relies on in making decisions about proposals like this. And I heard a number of things that I'll address in a minute, but I think what's clear from reading the criteria is that privacy is very important in the design guidelines that are adopted by the county. And so if you're seeking an exception to the setback standards, you're really asking for it's important, more important, I think, that you demonstrate, you know, that you meet the privacy standards. So I heard a need, a need for safety and a need to rebuild stairs that are rotten and provide better access for elderly folks and we're looking at this proposal not just based on the two property owners who are here today, but someday somebody else will own these houses, and so whatever we approve, we assume will be there for some time, and so we want to make sure that it works over the long run. I think that we heard ideas from you about changes you might make to the project, screening, maybe plant material, maybe other stuff. I'm an architect. I can imagine a different way of doing this that would achieve the objectives of safety and protect privacy. We heard from the adjacent property owner some ideas about ways to do that. But that's not the proposal that's before us. The proposal that's before us is a deck that encroaches into the setback, the required setback, that staff has concluded, and I agree, would pose privacy issues for the adjoining property owner. And therefore, I am going to adopt staff's recommendation and deny this approval or deny this proposal pursuant to the findings and subject to the conditions of approval in the staff report. It's without prejudice. If you wanted to come back with a different proposal that meets this privacy standards, you could work with the staff to come up with something like that. But as I said, that's not the proposal that's before us, and we're not going to redesign it here at the public meeting. Given that, if anyone is aggrieved by my determination and would like to appeal this decision, they may do so by submitting an appeal in writing by May 1st, 2025, by 5 p.m., accompanied by a $1,962 appeal fee. That's the last item on our agenda. And so I'm going to adjourn the meeting. Thank you all very much for coming, and thank you, staff. Here are some public hearings